I'll call the meeting to order at 7:01. This is a meeting of the Town of Norton Zoning Board of Appeals. I am Tom Noel, and with me tonight, Brian Spangler and Jim Tenori. Also with us, Nick Iafredi, the building commissioner, and Brian Carmichael, our town liaison, an all-around good guy. We've got a full agenda tonight, so let's try to keep moving through. The first item on the agenda is building inspector appeal. The property is 21 Samoset Street. I think Mr. Junior is here.
Yeah.
Junior?
Yep.
Thank you. Yeah, come on up. And is this your counsel?
Yes.
You are.
James Creed.
Thank you. This has been going on for some time. I see Ms. Quessel is here, is that correct?
Yep.
All right.
I am, Mr. Chair.
Thank you. Good evening.
Good evening.
I'm not sure. I'd ask counsel, Mr. Creed, to pull this together for us a little bit. I have a few legal memos from you, opinions.
Sure.
Not a criticism, but for me, it's not gelling. What is it that your last letter from a week ago, I think July, whatever the date was, what are you trying to convey there? Where does that get us for the ultimate decision that we're supposed to be looking at?
Well, there's two aspects to what we're presenting to you tonight. What we had hoped to do is present the planning board aspect of it first, and then answer your question if we need to. Because I think the planning board aspect of it, that Mr. Junior sent you the minutes, not the minutes, but the video of the planning board meeting where they approved the street improvements that he has already engaged in and constructed on Bignell Street. If that doesn't satisfy your requirements here, then we can get into the back and forth on the memos.
Okay, fair enough. I understand that you were before the planning board in December, correct?
I was. He wasn't there.
Okay, sure, that's fine.
Yeah.
Before me.
There was, before you, before council, BC. So there was not a decision rendered from that meeting, from what I understand.
I never got anything in writing, although I asked for it, and the most I got was the video, because you can correct me if I'm wrong, I never got minutes because I don't think they were ever written or approved.
Okay, so we have a record of the meeting by way of minutes, understood, but,
It's actually a video.
yes,
And
by
my
way of video.
there's a vote by the planning board in the video, I believe at,
Right,
what time on the video?
1 hour, 26 minutes, they voted to do a conditional approval, and I
Oh.
satisfied those conditions.
Okay, then can I ask town council, Amy Questle is here with us by video link. Amy, what does that do for our final process tonight? Does it do what the applicant is suggesting it does? Which is
No, in my opinion, thank you, Mr. Chairman, in my opinion, it does not. I don't know anything about the planning board approval, but the issue that we have is that they are trying to make a lot buildable, and they're trying to claim that it's buildable by a frontage they've created, which is not the way to do it, because Bignell Street is not a street. They have most likely, and my file on this is extremely large, Mr. Chairman, but they most likely have frontage. It's not on it's Samoset, it's not on Bignell, because it's not a street, it's on the other street, I'm sorry.
There's frontage on Hope Street,
It's on Hope Street.
108.5 feet.
Correct, so they have frontage on Hope Street, and so that's the frontage that needs to be accessible, so the building commissioner, if that frontage was accessible, the building commissioner could most likely issue a building permit on that, because there's 50 feet of frontage and 5,000 square feet. The issue that we've been going back and forth for probably a year now is the fact that Bignell Street is not a street. It was never created in any way that a street should be created. It wasn't created by a subdivision plan. And so,
Okay, that was my understanding. What is the
Yeah.
applicant suggesting that the planning board did? And I'm not
I
privy
think,
to that
um,
meeting except
I
by,
think that the planning board might have been told that, that Bignell, I don't know if they were told Bignell was a street and they did street improvements to it, but it doesn't matter, because it doesn't get them anywhere, because the underlying issue is still that Bignell Street is not a street.
what has to happen for Bignell Street to become a street? I guess that's,
Oh, they have to go through subdivision. I don't think they can do that. We don't know who has rights to Bignell. That would be quite a task, in my opinion. But again, that would be up to them. But, they would have to file for a subdivision to make, so Bignell would become a street.
that's not what happened before the planning
No.
board then.
Yeah. That was just improvements to right of way.
That's kind of what I was
You
getting
can't
at.
do that.
What is it that the applicant is suggesting that the planning board gave them a right to do and how that affects us? I'm hearing from Ms. Questle that that doesn't affect us. The planning board did not do what would be required to be done.
That goes to the heart of the matter with your town council's opinion that Bignell Street's not a street and that it wasn't created by way of a subdivision. We take the position that it was created by way of a subdivision. We've provided you plans from 1945, 1948, and a deed from 1950. The 45 plan shows what the layout of Bignell Street as a pole line. And the 48 plan, and these are all attached to my June 20th memo,
Yep.
the 48 plan, and again, Bignell Street is shown, as are all the other streets that were created by Leon Lincoln, the exact same way. The exact same width and the exact same type of layout. On the 48 plan, he designates it as New England T&T right-of-way. Now, in order, and part of the memos, and I think where your question comes from, Mr. Knoll, is the legalese in that, is that in order to create a right-of-way by way of an easement like that, you have to have offer and acceptance. What's known in real estate as livery of seisin. New England Telephone and Telegraph at the time had to accept that right-of-way.
And they did not.
And they
according
did
to
not,
your
and I provided you
research.
the background research from Verizon, which is the successor in interest to New England Tel, that they never accepted, they have no knowledge of this right-of-way. It took me quite a while to get that information from New Jersey, where their records department is. And in point of fact, they also provided us information that in 2007, over the same right-of-way, they had to obtain an easement from the then owner of 21 Samoset Street to put a pole in. So that's the proof positive that they just had no interest in what had been known as New England Telephone and Telegraph right-of-way up until 1950. And that's when we get to Exhibit D, which is Leon Lincoln deeding out in 1950 that lot and calling that same right-of-way Bignell Street for the first time, as best I can tell from the records at the Bristol County Registry of Deeds. So that indicates to me as a matter of law that Mr. Lincoln never gave up the rights in and to what he's now calling in 1950 Bignell Street. And he gave up, as a pertinent to that lot, rights to the center line under Chapter 183, Section 58, and the right to install utilities under Chapter 187, Section 5, to the purchaser of that lot in 1950.
And who was the purchaser? I'm
It's
looking
listed on the
at,
lot as, sorry, their names are the
okay, what happened?
Bragdons.
So what happens to that?
Well, at that point it becomes, they have rights in and to the street layout, the Bragdons.
Okay,
And they have the right to the center line, the right to make improvements to it as a street.
but that doesn't turn it into a street.
Oh,
No, it
well,
doesn't.
no, General Laws, Chapter 41, Section 81 FF turns it into a street. That's the subdivision exemption under the subdivision control law. And the operative provisions of that, which I believe I also provided to you, state that it's somewhat long, but I'll read it to you.
Well, which
We can go-
letter?
I'm sure Amy and I will go back and forth over it.
Which letter is that in, or which, you say you provided, was that in, that wasn't in the June, was it?
I believe I cited to it in the memo, but I have a copy of it
Oh,
here for
okay.
you. So,
Oh, I see.
81FF, which is known as the subdivision control law exemption, so far as land which has not been registered in the land court is affected by the subdivision control law, recording of a plan of a subdivision in the registry of deeds before the subdivision control law was in effect in the city or town in which the subdivision was located shall not exempt the lot within such subdivision from the operation of said law, except, and this is the operative language, except with respect to lots which had been sold and were held in ownership separate from that of the remainder of the subdivision when said law went into effect in such city or town, and to rights of way and other easements appurtenant to such lots. This lot was sold in 1950, so it was privately held prior to the adoption of subdivision statewide, which was 1952, which is later referenced in this statute, and before your town adopted subdivision in 1955. So that provision applies.
55?
I'm getting that from your town council's memo.
Okay.
I have no independent knowledge of that.
I thought it was 74, oh, that's the zone.
That's zoning.
That's subdivision.
And it goes on to state, and plans and subdivisions which were recorded in the registry of deeds and subdivisions made without the recording of a plan after said law had gone into effect in such city or town and before February 1st, 1952, without receiving the approval of a planning board of such city or town, and this is again the operative language, shall have the same validity and effect as if the subdivision control law became effective in such city or town on February 1st, 1952, as provided above. So Bignell Street is a street, and it doesn't need to be approved by the planning board because it's exempt under the subdivision control law by virtue of that statute.
I take it town council disagrees with the applicant?
I do, Mr.
applicability
Chairman. So
of FF, but-
essentially, what we have here is, we have Exhibit B, which shows it as a pole line. We then have Exhibit C, which shows it as New England TNT right-of-way. Mr. Creed has indicated that it's not an easement, it's not a right-of-way for New England Telephone, so therefore it goes back to a pole line. So we then have it as a pole line, and then we have Exhibit D, where someone, Mr. Lincoln, named it Bignell Street. You can't just name it. It's a pole line. It's not a street. It's an easement. It's absolutely not a street. And I don't have in my voluminous documents here on 21 Samoset that goes back years. I do not have, because we did give an opinion on this years ago. So this isn't the first time we've done 21 Samoset Street. I don't have anything. I don't know what, I really don't know what he's saying about FF, and I'd have to look at that, but I don't have anything on that in writing, so.
That's part of council's letter of June 20, just so you can look at it later.
I have the June 20 letter, but I don't have where he's
Is it?
actually citing,
Bottom of
so
page 2.
He's just citing the statute, he's not citing any.
That's
case
what
law.
I was confused about. It's in the letter itself.
Okay, all right, if that's the case, then I don't agree. Yeah, you're right, I don't agree.
Okay, so another question. Just assume it's a street for a second. If there's sufficient or more sufficient frontage on Hope Street, doesn't that diminish the need to take any action? I mean, we can't find a variance. They're not asking for a variance, I guess, but, variance.
So, Mr. Chairman, I don't know what they're asking for. They're appealing the building commissioner's determination that the lot is not buildable. Problem is that I think, and again, they haven't actually provided us with any documents, but if Hope Street were to be improved, then I think the lot would be buildable and there would be no, it wouldn't even be before you. But I think what they're asking you tonight is that for you to overturn the building commissioner and say that Bignell Street is a street and therefore he only created, the 50 feet of frontage. Again, again, this is a situation where, you know, the lot was purchased for not a lot of money. And I think that, he's trying to make it buildable with the least amount he's trying to make it buildable.
Understood.
And, unfortunately, I don't think Bignell Street is the way to do it. If he wants to make this lot buildable, then Hope Street is probably the way to go. But again, I'm not seeing how one can take a pole easement and all of a sudden turn that into a street with 50 feet of frontage.
Is that a term of art, pole line or pole?
It is not, it's not anything that's known to me, and
It's
I would point out
listed on the
that,
on Exhibit B, it's listed as pole line.
Pole
Or
line.
it's shown as pole line.
and I would point out that on Exhibit B, and on Exhibit C, and on Exhibit E, the subdivider of the lots is Leon Lincoln. In the 45
I don't
plan,
have an Exhibit
in
B.
the 48
so-
plan, it's to the June 20th memo.
Yeah, mine ends at Exhibit D, I'm sorry.
Well,
Exhibit D, you said.
Exhibit D, yes.
Oh,
The
yeah, that's
point
what
is
I'm
that
saying.
Leon Lincoln is the subdivider in both 45 and 48, and he's deeding the lot out in 1950. So Leon Lincoln isn't some person who just transgressed onto the lot and decided to name Bignell Street.
But
He was
does,
the owner of the
He
entire
did,
subdivision.
But he did after he created the subdivision naming King Philip Street, Samoset Street, and then he named this as Pole Line. He didn't name it as Bignell Street. He all of a sudden came up with Bignell Street in whenever this deed, he just deeded out a deed naming it Bignell
Because he
Street.
owned all the rights. He didn't
Okay.
deed them out.
But-
There is no
That's
deed
not
out of
in
a
accordance
right
with
of way.
subdivision. There was
Council.
no subdivision, there was no plan naming it Bignell Street. It just all of a sudden
So
showed up.
your position then is that the 45 and the 48 plans aren't subdivision plans?
oh, look,
Defies
If they
logic.
don't name it, they name it as Pole Line, and they name it as New England TNT right of way.
You could name it as Venus. It doesn't matter what the name of it is.
let me ask a different question if I can. Then who owns it now? I mean, how did it get from Bragdon back to,
It's a private way, and butters on either side under chapter 18358, which is the derelict fee statute, owned to the
That's
center
your-
line.
that's your position, that it's a private way?
It's a private way.
Owned by Bragdon?
He has the derelict fee statute benefit. You have the right, you own to the center line in a
Yeah.
private way,
Okay,
okay?
yep,
But it's subject to the rights of others who have rights in that way to pass or repass over it.
okay,
So the purpose and the reason it's called the derelict fee statute is in the Commonwealth, land just can't not be owned. If a right of way goes away, the title has to go to someone.
so we don't know where Bragdon is? Bragdon's
Well,
not in the
The
picture.
property's been sold over and over again, and those rights go with it. The rights to.
I bought his rights.
Well, that's what I'm asking, did you buy rights as described in Exhibit D?
When you
Or did you buy
when you
the
buy the
rights?
lot, unless the subdivider, the original subdivider of the land, reserves the right of way to himself.
Okay.
And has to be specific language in the deed where he does that. He gives up the rights to the center line.
That's your memo, okay, you're putting it together for me,
Right.
so
Sure.
I at least can follow
Yep.
what, pieces are saying, so I understand that.
The other question
But,
that
go
I
ahead,
would
Mr.
have, if she says I should do 50 feet of Hope Street, how do I get to Hope Street if I don't have the rights to Bignell Street?
I'm not sure I can answer that,
I don't,
but
do I just go out in the woods and pay 50 feet of Hope Street? Out in the
Now,
middle?
does Hope Street connect to another cross street?
Bignell Street.
Big now.
well, it goes
That's the
further.
only cross street that it.
It's gotta
that
be
it
another street,
goes to?
correct?
It goes
So
to, it
there's no,
goes,
Dead
there's
end
no
Philip.
street to
it goes
the,
beyond Bignell.
to this south?
Bignell goes another,
Hope Street doesn't touch any other street or right of way or access point,
Oh.
other than
So Hope Street
Bignell.
just ends?
It's a dead-end paper road.
No, it ends, but it ends at the other end?
yes,
There's no cross street ever?
No,
it's only 200 feet long.
Let me look on the, I don't think it doesn't matter for us, Mr. Chairman, but, that seems very strange for
So,
a subdivision to have a street that doesn't,
Okay. So-
it's very unusual to have a street that only connects to a pole easement.
then
That doesn't,
Hope Street itself, is that a accepted road or not?
No, it's the
It's
same
not.
status as Bignell Street.
Okay,
It's a private way open to the public that is not constructed as
Okay.
trees.
so if
So,
this,
so Hope Street does exist.
It's trees. It's a layout, just like we're contending that Bignell Street is.
Yeah.
But
So does the layout connect to another street?
Bignell
Sure it
Street.
does. It only,
The only
you're
way-
saying it
yeah.
only connects to,
the only way you can get to Hope
I
Street
doubt it.
is by passing and repassing over
Bignell
Bignell Street.
okay,
And
so.
there's
if-
no lot lines between them. They're all connected. All the street layouts are connected. There's no divisions of land between the streets.
I didn't know that, and I must have looked at something else, or I'm remembering something else, but I'll accept that. So if this comes down to legal argument, what we're supposed to decide is whether building inspector erred, right?
Well, it's a matter of, is the constructed portion of, would we contend as Bignell, satisfactory to provide 50 feet of frontage to the lot?
No, that's
the
not what
question.
you're here for, Mr. Chairman.
Yeah, it's an appeal of the building inspector's decision.
Correct.
And I'm looking for the
Wasn't that the
statute and the bylaw for appeals. 175, yep.
It just seems to me that in order to pave another 200 feet of a dead end that doesn't go anywhere, it doesn't make sense. If I have to
So
do
where would
that,
the 200 feet get you to?
Hope Street.
Hope Street. I would have to go up Bignell and go down Hope. It's the only way to get there.
No, no, that's not what I'm asking. Hope Street has to it has to come out somewhere besides just Bignell. It doesn't just dead end. I know this from before.
I
I've
would
looked at
differ on
it
that
before.
based on the plans.
I'll have to go
Okay.
through my entire file.
So where is the bylaw on our duty with respect to building commissioner's decision? I'm just looking for the standard. I thought I had tabbed it, but I have not.
Hold on, Mr.
Chapter 10,
Chairman,
Section
it
8.
is,
10.8, Tom.
There it is. Thank you. Just saw it at the same time. 175-10.8. Thanks. The Board of Appeals, us, may hear and decide appeals taken by officer or board of the town or by any person aggrieved by not being able to obtain a permit from any administrative official. That's what's happening. That's what this is. That's why it's before us, correct?
yes, okay, that is right. I'm assuming that Nick made a determination and they appealed it within 30 days, but that should be checked to make sure that it's timely.
Yeah, Nick's determination letter is in the file.
Okay.
I'm looking. My file's not as thick, but it's more confused than yours.
So this goes back to, at least my file right now that I'm just glancing at goes back to 2006, that we've been dealing with this.
I didn't know that.
Yes.
So, if I may.
Yeah, go ahead,
Chairman?
Mr. Iafredi.
Amy, the way this came about was, I believe, and Mr. Junior can correct me if I'm wrong, but I believe the parcel was up for sale and the prospective buyer had submitted a building permit application.
Correct.
And I denied the building permit application based off of the grounds that we spoke about in the opinions given. So it was actually a denial of a building permit application for the construction of a house on this property.
And they would have the ability to appeal your denial of a building permit
That's a
to the,
letter January 8, 2024.
Correct.
Is Mr. Brawley the prospective?
James Broley was the prospective buyer at the time, or he
Okay.
was the applicant on the building permit application.
Basis of denial is that the parcel of land known as 21 Samoset does not meet the basic zoning requirements set forth in bylaw 175, sections 6.2 and 6.3, therefore deeming it non-buildable in its current state. The parcel consists of 40 feet of frontage along Samoset, and in bylaw 6.3, small lots recites what a small lot is, must be a minimum of 50 feet, and a minimum of 5,000 square feet of lot area. So that's what's being appealed in this process, this current stage of the process, as far as I can tell.
Mr. Knoll?
So we have to determine whether the building inspector went beyond his discretion.
yes,
And of course, the building inspector was relying on an opinion from town council, Ms. Quessel's office at the time, which we also have. I mean, we're not a court of law here. I'm just a little, and I'm not a judge, and we're not judges. We have to apply the bylaw, and that's that. So I'm just trying to simplify it to what we're looking at. Either side gets to take it to the next step, which would be Superior Court, I suppose, or Land Court.
One or the other.
Could I,
Yes.
Yeah, I would just like to submit for the record
Yeah.
the assessor's plan. So this, which shows that Hope Street's a dead end.
Thank you, thank you.
And has no other connection other than Bignell. And I've highlighted in blue.
That's the assessors, for the assessors.
Bignell comes off, it's the official, copy of the official.
Yeah.
so the only way to get to Hope and pave Hope is to do the rest of Big Now
I guess,
and then do Hope.
understood.
And that's where I'm scratching my head. Why am I going another 200 feet to nowhere when, if they're all connected, the first street, I would have to have the right to pass and repass over the first street to get to the second street.
So when did you pave?
I would say, Mr. Chairman, I would say that Bignell Street is not a street, so that means that his only frontage is on Samoset, and he doesn't have enough frontage.
Yeah, I was just asking, when did you improve, Sir Bignell? When did you do that paving?
Within the last year.
After the planning board or before? Or-
Before,
It was before the planning board. And then I went to the planning board and I said, this is what I did, is it okay? And that's what shows in the video. And they said, no, but if you move the pavement over a little bit, because I had skewed the pavement out of the right of way.
That's the 110 square feet.
Oh, yeah, right, yep.
Okay.
They said if you move the pavement over a little bit and put a note on the plan from an engineer regarding drainage, you have our approval. So they gave me a conditional approval if I did those things. I did those things, and then I gave them a new as-built.
But they haven't acted on it to deem it a road.
Well, they gave me a conditional approval. They said, do these conditions, and we approve it. So
So
that's what I did.
that's, I mean, I guess what I'm saying, or asking council, that's not part of our record that's before us. It's, the video is the video, and I understand what the applicant is referring us to. But wouldn't it have to go to planning board for a final approval?
Yeah, we would have to do
That
a
is-
subdivision approval. It's not a road.
I'm not subdividing anything. There's no
We're
new
creating a
lot.
road.
Okay, so I'm completely in the dark as to what could be appropriate here, or would be appropriate. I assume that the building inspector didn't have any better information, I mean, any different information than what he's heard tonight. I just don't know what else to do with this, members. Do you, first of all, questions from members, Jim or Brian?
Who paved Hope? How did Hope even
It didn't,
Hope is not paved.
Hope is not paved right now,
No.
not right now.
It's woods.
It's woods right now, okay,
Yeah.
it's paper road.
and there's 40 feet of frontage on Samoset Street.
Yeah.
And I think that's what Nick was saying, it doesn't fit under the small lot 6.3 either, because the only frontage that's there is on Samoset Street.
And there's only 40 on that.
Right.
And you need 50.
Exactly.
That's why I went up Big Now, and I did 50 at Big Now, so we would hit 50. Essentially, I have like 300 feet of frontage, but only 40 is on Samoset, which isn't enough, so I did 50 at Big Now.
I just wanna go back and read the,
Sure, and I guess I asked town council, where do we go from here on this? Is there anything further that you want to take a look at, before our next meeting? This has been kicking around already for several months here. Or are we in line to take a vote and as to whether we feel the building inspector acted outside the scope of his authority?
That's to you, or I guess, or if the, if the applicant has further information they want to provide, but I don't see any way that Big Now Street all of a sudden became a street.
So Bignell, only 50 feet of Bignell is paved.
Correct.
So it does not extend down toward the bottom of this page.
Right, the right-of-way does,
Right.
but only the pavement goes 50.
And again, he's calling it a right-of-way because it's not a street, it's a right-of-way, it's an
I
easement, it's a full
understood.
easement.
No, I get it, I understand. I thought these connected to other roadways.
No.
I
That's
wasn't
it.
familiar with that area, that's all. So, go ahead, Jim, did you, or Brian, did you have questions?
Not really. I mean, for me, I think it's pretty clear that Big Nell is not a street, and the frontage requirement isn't met for me.
Jim, did you have a question, or?
no, I just went back and read, planning board's kinda, their main memo back to us.
Oh, from just, yes, his email.
Yeah, his email, that's what I meant.
But it's not, it doesn't explain.
Yeah, it doesn't explain anything on that end. I just wanted to make sure.
I think our question is whether the building inspector acted appropriately. And I'm assuming, based on the building inspector's letter of January 8th, he's saying exactly what council is saying. Parcel currently has 40 feet of frontage along Samoset. And that's not within the small lot exception in our bylaw. The rest to me is, it's interesting, but it's legal positioning and legal argument. I don't know how to resolve that at a board level like us. That's why I'm asking,
I would defer to our council.
well, we have deferred to
Yeah.
town council, and I guess town council and Mr. Creed, is there more for us to consider? Is it, I'm not asking you to continue this, but is there more for us to consider?
I think as long as town council's taking the position that no matter what is presented, that there was no street created, notwithstanding the plans that were all created by Mr. Lincoln and the deeding out of that lot by Mr. Lincoln, whether he called it a pole location or a pole line or a telephone right away, he didn't grant any rights by way of a deed. No one accepted rights by way of a deed, so the easements of the right-of-ways were not created. The roadway is shown just as all the other roadways. It's the same as Hope Street, it's the same as Samoset Street. It's a subdivision road, and it was created prior to the adoption of subdivision. It's entitled to the exemption under 81FF. The language couldn't be clearer.
But
But as long as town council's taking the position it's not, I assume you're gonna follow her advice, and you're gonna deny this. And that will lead us to a choice as to what we do next.
Okay, so the taker in the deed, Exhibit D, Bragdon, has did nothing with that deed?
He didn't have to. He bought the property and he had the pertinent rights to what Mr. Lincoln called in that deed Big Nell Street.
Did he take the main property as well?
That's what he's saying. He was-
So I think you're getting confused. He didn't buy the right of way. He bought my lot. He's the
Okay.
predecessor to my lot.
He is, okay.
And he also had rights to what we contend is Big Nell Street.
Well, right, but this is a
Which means-
separate instrument.
Which means we
Your
can-
counsel is saying granted the rights in Big Nell Street
Right.
separately.
No, they go with
Come
us.
with it. That's
If
what I
you,
got.
if you describe a lot bounded by a street, you have the rights in that street unless the grantor, in this case Mr. Lincoln,
Yep.
reserves the rights
Okay.
to that road.
Yeah.
So this is
In other words,
the
he would have
This is the
to
deed.
have specifically kept the street
Yeah.
as his own property.
Yep, I
By
understand.
not reserving it, he grants those rights, and those rights are under, and I know this is legalese, but he grants those rights subject to chapter 18358, which is the derelict fee statute, which allows the rights for others to pass and repass over that street. So you can't build anything in the street.
No.
You can't obstruct the street.
But people did not pass on it either as a street.
Well, they don't have to. It just exists because it was laid out prior to 1952 and the lot was sold.
In other
So it was
words, there
sold
wasn't-
off from the other subdivision.
In other words, back then, when you did a subdivision, planning board didn't exist, so there was nobody to sign the plan. So all he did was go to the registry and record it, and that divided up all the land and showed all the streets.
So does your argument apply to what's shown as Hope Street also?
Yes.
Yeah.
So you
So,
could,
Mr. Chairman, the biggest difference here is that under 40A, Section 6, Paragraph 4, the isolated lot or the separate lot protection is that it has to have 50 feet of frontage shown on a subdivision plan, and this does not.
Yeah.
This has 50 feet of frontage shown, this has 50 feet of frontage on an easement. It has more than 50 feet of frontage shown on Hope Street, but you cannot, the subdivision plan does not show Big Nell Street. Big Nell Street was created by some deed. Somebody just decided to change the name. You can't do that. You can't just go about changing names on a deed.
And again,
It
it's not
doesn't-
somebody, it's Leon Lincoln, the man who subdivided the land
Understood.
in 45,
Understood.
re-subdivided it in 48, and renamed that right of way, and then
You
named
can't
it a
just
street in
rename a
Big
street.
Nell. Because,
but,
Mr. Chairman, if I may finish?
well, yes, go ahead.
Thank you. So under 40A, Section 6, Paragraph 4, it specifically states that it has to be shown on a subdivision plan. It's not. He changed it, he just changed the deed. In fact, what I find, I have it in one of my documents here. Oh, actually, it's shown, it's in the June 20th letter
Yeah,
where someone just crossed out New England right away. They just crossed it out and, put Big Nell. That does not give you protection on the isolated lot protection or the separate lot protection. It has to be on a street shown on a subdivision plan. You can't just simply take an easement and turn it into a street. And that's where we're at here. That is the issue here. Nick can actually attest to the fact that this is not our first 40A Section 6 Paragraph 4 issue that we've gone through in town. Nick and I have gone through quite a few of these in town, and it's the same. We go through the same process, and if there's a street shown on a subdivision plan, and they have 50 feet of frontage, and they have 5,000 square feet, and there's been no merger, it's always been held separately, then most likely they have the exemption. Here, unfortunately, they don't have the exemption. Big Nell Street is not a street shown on the subdivision plan. It's a pole line shown on the subdivision plan. Hope Street is, but if they claim they can't do Hope Street, they can't do Hope Street. But
okay.
that's where we're at right now.
So, another question, could the applicant, given what he's arguing, improve Big Nell and improve Hope, or a portion of Hope, go back to the planning board and get subdivision approval, or not? I mean, is that a remedy that he could
If
pursue.
he has the right to do that, that would be him, it's subject to other people that have rights in the pole easement
Oh, right.
and rights in Hope Street, but if he
Because,
has the rights to do that, that's a private matter up to him, but,
because then
he could-
anybody else can use those streets, as the applicant is stating. If you take the applicant's argument, anybody can pass those streets now.
right, most likely, any improvement would be in accordance with, the derelict fee. I don't know about in accordance with New England Telephone, if they still have an easement or not, We
Applicant
just
is
got an
saying
email
they,
saying we got an email saying they can't find the easement. We don't have an
Okay.
email saying they definitely don't have an easement. So unless we have a full title search saying, they did, and even then, I don't know what we would do about that. But it's listed on the subdivision plan as New England Telephone right of way.
oh, because I note that what's called Hope Street, where there's 108 feet of frontage, quote unquote, and then Bignell, there's 140 feet of frontage, quote unquote, if it were a approved road. The plan that was given to us wants to use Bignell Street because it allows for a larger house, because it has to be so far off the front street under the small lot exemption, I think.
Yeah,
In other words, applicant using the frontage would have to reposition the intended construction there and doesn't wish to do so, and I understand why applicant doesn't wish to do so. But it seems to me that there are options here, and it's not up to us to sort of create a new rule. So I'm gonna ask if there are any further questions or comments from the board members, or from Mr. Iafredi, or council, or town council, and ask if there's a motion to take a vote on whether the building inspector exceeded his authority, which is what's before us.
I'm all set.
I'm good too.
Is there a motion that to deny the applicant's appeal of Mr. Iafredi's decision of January 8, 2024?
I'll make that motion. Second.
Motion's made and seconded. Is there any further discussion on that? In my view, Mr. Iafredi acted in good faith based on town council's opinion and the file that apparently has been going on on this particular parcel for some time. I don't see how we could say he acted improperly or outside of his authority. There's a disagreement, an earnest disagreement, and I follow now what counsel, Mr. Creed, is saying, but to me, that's an issue for the courts.
Correct.
If the courts are to be involved by either side, or there's an avenue to do these improvements and get it actually approved by the planning board, which is, I understand, the process for doing that. We don't do that in this board anyway. So that there are options, and it's not up for us to direct which option is to be taken. That's my view on this.
I feel the same. Well said.
Okay, then, the motion is that I believe that Mr. Iafredi did not exceed his authority or act discriminately in denying the application by way of his letter of January 8th. Mr. Tenore, how do you vote? That Mick did not exceed his authority or act improperly.
Yes.
Mr. Spangler
Yes.
and Mr. Noel votes yes as well.
Thank you.
I hope you're able to work out some other solution, but thank you for explaining and for talking us through.
Yeah, thank
Thank
you.
Good luck to you.
Thank you.
Good luck to you.
Thank you.
Okay. Item 2 on our agenda is to be continued. I have a note. It is property address 0 Burt Street. The applicant, Dan Rich, Attorney Rich, is here. We got notice that this is going to be continued, however.
If I could just, if I could.
Yes.
Yeah, what had happened is after we had filed this, I think it was last week, I got an email from Mr. Iafredi and from Brian. They're looking for a plan where the house would be drawn, and we have a plan of the land, we don't have a plan where the house would go. I tried to stop and see Mr. Afraid several times, but he's very busy in town.
Sorry.
I didn't know what type of plan he was gonna need. Is he gonna need a plan by an engineer, or how do you want this plan so we can come back? Because if it does, I may have to amend my application.
So if I may,
Yes, please.
I think, yeah, I think we need to see a proposed plot plan, so we can determine.
Show him where the house is.
Yeah, because in my opinion, I think we need to be able to determine whether or not we need potential variances for side yard frontage, setback, whatever the case may be. With just a vacant mortgage inspection plan, it's tough to determine. And what I don't wanna see is have a ruling today and then you have to come back because now we have a house on a lot and need other relief.
Well, it has to be an engineered plan, signed,
Yes,
stamped by an
certified,
engineer, showing us the dimensions of what's there and what's proposed. That's what we act on. So, yes, I certainly agree with that discussion.
Okay,
So you intend to do that? and-
We'll have to. I can't use a mortgage plan.
No.
Right?
No, and
It has to show the
Yeah.
location regarding the setbacks and the positioning of the intended construction.
Okay.
Our next meeting is, do you
August 21st.
intend to do this
Oh,
by?
absolutely, yeah. I
So-
couldn't get it done in a week, that's
No, understood.
that's why I stopped.
So we'll continue this to August 21st? Is that agreeable to the board?
Yep.
Mr. Rich? So we'll continue to August 21st?
Yeah, I'm going to talk to you just a bit.
Thank you.
Yeah, whenever, absolutely. I did try calling you back for the record, but you're tough to get in touch with as well.
You didn't hurt your hand by fist fighting Nick?
No, we're friends, we like each other.
Him?
Yeah, I know.
I do crazy things, so that would be lovely.
I hope your finger is better in the next couple of weeks. It looks painful.
Thank you.
So August 21 is the next meeting.
Thank you. Yeah, what time?
We start at 7, we'll say 7.
We will be at the media center.
And the media center is?
184.
184.
Oh, we're back there.
Park Shop Credit.
Yeah,
Okay, thank you.
okay, thanks, thank you. Next item on the file is the variance application for finding 3 Bryan Road. Jacques Bissett, Mr. Bissett? Yeah, thank you, yeah, come on up so we can talk to you.
What I can say is, Mr. Lincoln, I hope, did not build my subdivision. Just saying.
No, I think this is simpler than what
I
we
hope
saw.
so.
And apologies for everybody else who came on these
No,
other matters.
no.
We don't always order them, put them in the
No,
right
it's all
order
right.
here. Because I know yours is, you are 3 Bryan Road, correct?
Yes.
So let me just ask a general question. Nick has just stepped out. Was there a denial of a building permit here?
No, I
Explain to us why you're here.
I needed a variance because of the lot size. I did all the proper paperwork. My wife and I have been here for 25 years. We plan on staying. My daughter, my son-in-law, my granddaughter, we're gonna live in the main house, we're gonna live in the in-law. I brought everything to Nick, checked with him, double-checked. Everything is in line. It looks like a pretty easy build. As soon as I get the approval, hopefully, God willing, it'll go fairly quick.
Okay.
My wife and I can enjoy being in Norton, and for the record, I live 1 street over from Ralph Stefanelli, so I just think I should get a sympathy vote for it.
No comment. No, I see, and I looked at this earlier. So the planned construction, am I right that it's above the existing garage?
It is,
There's a garage there now, and you're gonna build up on top of it?
yes. We're
Okay.
gonna put an in-law above it, connect it to the main house.
Yep.
Do any of the setbacks change? No.
Nope. I went over all this with Nick to make sure that.
Yeah, no, he stepped out, so
Yeah.
I apologize for asking
No,
something.
no, no,
Go back.
I wouldn't have done any of this without checking with him first.
One question I wrote down, where are the structure dimensions? Where do we see how much square footage is there now? And
Well, the garage itself is 24, And the
Is
biggest
that
thing,
li- Is that listed here?
it should be,
Yeah, I had the same question. I didn't.
yeah, it's
didn't see
24,
it.
24, and what we're gonna do is overhang the front by 4 feet.
So that's 4. It's a little hard to read the
See,
printing.
and this says something different. This says a 6-foot overhang.
It does say 6?
Yeah, it might have been,
Thank
Nick, you know, Nick had the old
It's in lighter
blueprint.
ink, right?
He has the
Right.
updated one from the lumber company, which was the engineered lumber, because everything has to be
Okay.
engineered. So it's only, it only can be 4 feet. And I
This is the
think
only plan that I think is
Right.
uploaded to
That's
our
right.
Yeah,
system,
Nick
so-
knows it's 4 feet, because I gave him another set of plans from Cape Cod lumber. So
Well,
he should have that.
And it looks like there's a new deck that's part of the improvement as well.
It's gonna overhang the backyard, which is overlooking the pool.
Yep.
we're gonna see the new
That,
deck.
there's a 6-foot deck, and that's probably for the a dedicated entrance
Yeah,
up on the
that's-
site.
It is
Yeah,
for,
deck.
for
Can you point that out?
Right here.
means of egress.
Oh, that deck wraps around.
Yeah.
Yes.
The
But it's-
printing, the blue ink didn't come out on my
Oh,
printer
okay.
very well, but I see it. I see what
And
you're
there's a
saying.
breezeway that's
Yeah.
new as well,
Yes.
to connect back to the existing house.
Okay, Nick, we're talking about Brian?
Yep.
Not me. No, not this
Mine
Brian.
was fine.
Or this Brian.
He's saying there's a
Brian
date
Road.
plan.
Is there an updated plan, Nick?
Nick, remember the front only can go 4 feet, and I thought I gave you the copy of the Cape Cod plan.
The plan that we have shows an overhang over the front of the, or is it the front? Yes, the front,
Yeah.
Brian
Yeah.
Road front. An overhang of 6 feet, right?
It's only 4.
That's what's on the plan.
But is there an updated plan that's not in our file?
There could be. He may, yeah, and I apologize.
No, that's
It was
all-
a long time. But I do recall having a conversation about the overhang and having to change it to 4 feet for potentially structural reasons.
Structural reasons and because of the micro lambs and stuff like that, it made more sense to make it a little bit smaller so we didn't have to deal with a lot of structural stuff.
But do we have that plan to go on tonight? Is that an engineered plan?
It is from the lumber company, yes, it has to be. And that's why I made sure Nick knew.
It's an architectural plan. The site plan wasn't updated.
Okay.
It was the building plan
So
that
we
was
have to
updated,
use
correct?
this
That
and
was changed.
say, accept that overhang
Yeah,
and
it only
Brian
goes
Road.
full.
Yeah,
side
so the front setback would be changed from 36.4 to 38.4. You would just add 2 feet to that setback
That's-
from the front yard.
Thank you. Yeah, right, because I had 36.4, where did I get that?
That's current
So that's
proposed
with the 6-foot overhang.
Oh, that's 42.3 minus 6 feet, right. My question was, how do we get the building dimensions here, or the buildable, livable area? That's not shown on this, is it?
I don't see it.
It is not, but I think if you write in your decision, as we've done in the past, that the accessory dwelling unit cannot exceed the 750 square feet allowed in our bylaw, I think you cover, I
Does
think you have
this,
yourself covered.
does this not, I mean, thumbnail
This
it?
does not exceed 750 square feet. I've
Right.
worked with Jacques on
Okay,
this before he
that
came
was
in.
my question. I mean, we like to see it on the plan, the dimensions, there's cells on the plan, but I took out my calculator and I didn't see dimensions here, so, thank you.
Mhm.
So the new shall not exceed 750 square feet, does that include the breezeway though, or is that just, and the overhang?
I think, so I think, again, if I
That's
may.
livable space, right? It's-
But if it's deemed common space, I don't know if we calculate that within the accessory dwelling unit. I think we've gone through this before.
Yeah, we
We
have.
did,
With one, actually this
Yeah.
past year, I believe, in the fall and the spring.
Yeah,
That if it's common space, it's technically, I wouldn't deem it part of that 750 square feet.
so the deck, for example, at the breezeway,
No.
that's not
Yeah.
considered livable or whatever it says in the statute, bylaw, okay.
so, let me just clarify.
Yeah, please.
So, the current garage does not have the overhang,
Correct.
The overhang would be on the second story,
would be
right?
on it, does
Yes.
that change would he, because that would obviously be under 50 feet in the front,
But it is now, it's 42.3.
okay, but the overhang doesn't change it though, right?
It does.
It does.
It does.
You project it
So-
onto the ground.
Okay,
So he would need the variance. and-
That's what I'm saying, you
Yes.
need a variance on that.
Absolutely.
Okay, yeah,
From
that's what I was getting at.
noting that it's currently, closest place is already 42 feet, 3 inches.
Right,
We would be granting it for that new construction over the garage down to 38.4?
yeah, and you would need the side as well.
Right.
Yep.
And that's 11.8, that's the 15.8 shown there minus 4,
Yep.
obviously. Is that deck ground level deck?
No.
Or upstairs?
No, it's gonna be upstairs. for
That's
means
upstairs.
of egress. Yeah, I'll have two.
Oh, I see the stairs, yes,
Yep.
thanks, thank you. We like to see as much detail as we can on this, that's why I'm asking.
Well, it's kinda small, so it's,
Yep. And plus the printing, the blue ink didn't print out well on my printer. But I see the references that the applicant's making. Are there other questions or issues?
My only question, and maybe Nick has already looked through this, but there's other requirements here that we're supposed to check, you know, that it has a kitchen and a bath.
Yep.
We don't have a floor plan, so,
What is that section that has the
this
requirements?
is 175, 2 point, it's actually the definitions.
175, 2.2?
Yeah,
Yeah, because we've included reference to that in other decisions as
Yeah.
well, that the requirements shall be met as, this is accessory apartment, right?
Yep,
Right.
accessory dwelling unit.
We're saying in-law, but that's what,
Same.
under the bylaw, it's
Yeah,
accessory. So,
Yep.
are there other questions for the applicant, or do we need to see other things on the plans? I think we can probably write in
Yeah, I
what we
think you
need.
yeah.
It seems to be well thought out, and given what's there already, this is going up, not outward by that much, so.
Yep.
No other questions or issues?
Nope.
Mr. Iafredi, you agree?
Yeah, I agree. I believe, just to a clarification, that this is it's a finding, a side yard setback and a front yard setback.
Yes,
Front yard
that's the way I see it.
setback. Okay,
me as well.
so yeah,
The concrete for the swimming pool, not that that's not before us now. We asked you this before. Concrete can go right up to the property line? You don't have to, it's not considered a structure?
No. No, I don't believe the bylaw has anything that
Yeah.
prohibits that.
Interesting.
Yeah, I've never seen any of that.
I mean, often we see there'll be a pool with a deck around it, and the deck is a structure, but concrete slab is not, huh? Okay, just curious, Jen.
well, it has a bar on top of it, so.
A what?
A bar.
Don't tell us things that we, yeah, and is the bar open? That's what we-
Well, if we get this meeting over.
No, you can't do that.
Let's take a look.
This is in line for a finding under
1.6.
175.16, that this planned alteration, addition, shall not render the use substantially more detrimental than what is there in terms of noise, except for the bar, and the other factors in the bylaw. Is there a motion that this passes that requirement, that this shall not render the use substantially more detrimental?
I'll make that motion.
Second.
Is there any further discussion on that?
Nope.
Mr. Tenori, how do you vote?
Yes.
Mr. Spangler?
Is there any, input from community folks?
Thank you. Thank you very much. And I didn't ask for the vote to close off. Is there anybody here to speak in favor of or in opposition to this application?
Mr. Chairman, I'm not speaking in favor or in opposition, but I did just want to let you guys know that you have a special, you have a kind of a interesting take on what your bylaw defines as structure. And it says that a structure is a man-made arrangement of materials requiring a fixed location on the ground,
Yeah.
blah, blah, blah. But then it says that the use of all structures shall conform to provisions of this bylaw, but only structures projecting above ground level. So if you have concrete, apparently you can have concrete to the lot line on your, under your definition of structure.
But it shouldn't be above ground level, apparently.
Oh, yeah, so I mean, you could have a concrete slab, but then you can't have railings and stuff.
Yeah.
So, It's interesting,
I'm sorry I asked the question, but yes.
yeah.
I'm not suggesting Nick go back out to see if
Yes.
it's 6 inches or 4 inches up. And then,
I wouldn't worry, as long as someone's projecting.
thank you,
So-
thank you,
I
Council.
didn't hear any community objections.
No, and no other comments from the community by way of internet, so,
I'll vote yes.
yes, we'll continue with our vote. And I take it there's a motion to close the public hearing sector of this.
Yes, I'll make that
Can you do
motion.
that motion first, please?
I'll make that motion.
Is that seconded?
Second.
Mr. Tenori?
Yes,
And Mr. Spangler?
Yes.
yes.
So the public hearing is closed. And now resuming the vote, Mr. Spangler has voted a yes, that this is appropriate under 175, 1.6.
Yep.
Then, for the variances necessary, is there a vote that the applicant is granted a variance on the side yard, which is the westerly side yard, down to 11.8 feet as shown on the plan of record? It's already at 15.8 feet, and the applicant has shown the criteria for variance relief. Is there such a motion?
I'll make that motion.
Second?
Any further discussion?
Nope.
Mr. Tenori?
Yes.
Mr. Spangler?
Yes.
And Mr. Noel votes yes as well. And then the front yard setback, present setback is 42.3
Yep.
feet. Here we have to note that the overhang shown in the plan of record, though it says 6 feet, shall be 4 feet.
Yep.
It differs from the plan submitted, but it will be noted in the decision, so that the front yard setback will be no closer to Bryan Road, I almost said Bignell Street, shall be no closer than 38.4 feet. Is that math correct?
Yes.
Is there a motion
I'll
to
make that
grant that
motion.
variance?
Second.
Any further discussion internal? Mr. Tenori, how do you vote?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes. I think that's all we need to do on this. Good luck to
Thank
you.
you very much for
Good
your
luck to
time.
you.
I appreciate it, thank you.
Thank you for clarifying
Thank you.
everything.
Thank you.
We'll drop the decision, and then it has to be posted for a certain amount of time, and
Thank you, Mr. Freeze.
thank you.
Talk to you soon. I'll text you, sir.
What's next?
Next is the application for finding 11 Union Road. Justin Flannery and Rita Todd. Come on up. And I had gone over this today as well, and this looks fairly straightforward. Are you, can you identify yourself for the record?
I'm actually Rita Flannery, but Rita Todd on the town record for some reason.
Okay,
I'm Justin Flannery.
My name's Steve Medeiros, I'm an architect.
okay, and we
The
have,
application?
the letter is from you, Mr. Medeiros.
Yes, it
So you're
is.
gonna present for the applicants?
Yes.
Sure, and thank you. I found the letter very clear. We often ask, why are you here? In other words, how did you get here? This tells us exactly why you're here and what you're looking for, and I appreciate that.
Thank you. Yes, I was hoping that the drawings and the narratives somewhat spoke for themselves. But to summarize, my clients have an existing house of about 860 square feet, and with one bedroom.
800 and what?
884. I
We
believe.
have 90 here, that's why I'm asking. 890 square?
Oh, I may have rounded up.
Okay.
Yeah, 890 square feet, yes.
All right.
And they are hoping to get another bedroom, as they are soon expecting to expand their family. And we looked at a couple of variations and deemed this the most logical and simplest, and also most conforming, in my opinion, given that it's completely within the required setbacks.
Right. So this is a pre-existing non-conforming lot, I take it? Existed prior to zoning?
Yep.
Yes.
Because pre-existing due to frontage does not meet frontage, lot size, and front setback, it looks like? I wrote down front setback.
It doesn't meet any setbacks.
Any
The entire
setbacks.
house is outside of the setbacks. If you look at the existing site plan,
Oh, I see.
you
Yep.
need a bigger one.
You know, I can see it again, the ink is not,
Yeah.
I'm gonna replace the ink in my.
Yeah, the entire house is outside of the setbacks,
Yeah.
and there's no setback reductions for undersized lots that I know of. When I detailed through the zoning. So yes, our new, so we're proposing a 2-car garage with a master bedroom above and a connecting piece between, which would provide the stairway up and down.
Right.
Because his finished floor is about 5 feet above ground. And yes, we're proposing to add approximately 703 square feet, which is more than 25% of the livable space, which is why we're here requesting the approval of the findings.
Looks nice, so the room would be above the garage.
Sure. Oh, I did provide an elevation.
And, yep, I see the current dwelling is non-conforming as to all setbacks. But the proposed addition, or garage, is conforming.
To all of them, as
Right.
far as I understand.
So under 175, 1.6, whatever subletter, we are only looking at whether, because this is more than 25% increase, we're only looking at the simple question that we faced at the last application. Does this make this substantially more detrimental in a non-conforming status?
I
Oh,
think
you got it there.
the deck does fall outside the
How so?
setback, it looks like. So we might need a
Where?
fine as well. The proposed 5x13 deck, the
Oh.
plan west side looks like it falls outside the,
You are correct.
Setbacks.
That length was honestly fairly arbitrary. It's more of just a landing.
I don't think it's a big deal, I just,
Yeah,
we have to make two,
you're right.
we have to do 2 votes.
It's
instead
not,
of
that
one.
Sure, no, I
measurement,
understand.
that measurement's not here. Do you know what that distance is to that deck from the side yard?
I mean, if it's 5
14.1.
feet,
I will set it at whatever I say right now. I will say it goes 3 feet over the setback, and I will place it there.
It's very small.
yeah, that's fair.
Yeah, and it's oddly drawn because it extends beyond the breezeway. By a foot or
There's an
two.
existing chimney, which
Oh,
is that
I see
little
it.
double square.
Yeah, I see it.
So I just extended it beyond
To
that
cover
by
that.
6 inches
Yeah.
to catch it. But I would,
So we can say then side setback, what, 22? No closer than 22? Is that 3 feet? You think?
Technically?
I mean, we, again. we-
required side setback is 40 feet, so
Oh.
if we extended it
47.
3 feet, we'd be at 37.
So say like no more than 35. Breathing in.
This is an R40?
According to the site plan, yes, the survey, yeah.
So that's
Okay.
about 25, 10.
So
Oh, the reason I call it
Two
40 is
miles.
because it's a corner lot, so my understanding was there's two fronts,
Hmm.
and
Not, fine, I
I
think we
may,
usually,
I may be
pick,
mistaken there, but
well, we usually pick a frontage.
Mr. Chair,
Yeah,
I believe this is a corner lot, correct?
Yeah.
That's-
So our bylaw,
Yeah, that's correct.
it's
Consider front yard.
in chapter 3, is it 3? I'm sorry, it's 2.2, the last definition of yard.
yeah,
2/3 of the way down, on corner lots, front yard setback shall be measured from both streets. So
oh,
if there's
so it is
concern
front.
on that deck, technically, I believe it would meet the setback from the front yard. So he may not need a variance on that porch. I don't know, again, without knowing that
The question is,
dimension,
right, the question is whether it's 40 feet, right?
it's in R40.
You're showing a 40
It is
foot,
R40.
you're showing a 40-foot setback on both streets, right?
Yeah,
In the drawing.
I'm showing.
And I think
four-
that's correct.
In the
because-
new, in the proposed, I'm showing a 40-foot,
Right.
yes, on both streets.
Right.
weird.
So it's not dimension. I think what he's saying is this is 40 feet.
Yeah,
So this is
how
the
about
se-
going this way?
And this is 40 feet.
But how, if that's 14.1, how big is this dwelling? I'd like dimensions on these.
Oh,
The dwelling is 26 by 34.
So 26 and 14 is 40.
It's 40.
You're exactly 40.1, so yeah, technically he's encroaching in that front yard setback.
Yeah.
Numbers work.
Yeah.
But by 2 or 3 feet,
Couple feet.
so.
We're still talking about the deck, right?
But it,
Yeah.
yeah, but it would be a front yard setback variance, it wouldn't be a side yard.
Yeah.
Front.
Got it.
Right.
But is that, so do we allow 3 feet there? Write it in? I mean,
Can do 5, I mean,
De
I don't-
minimis.
it's not really gonna,
Yeah,
It's really stairs that comes out.
the stairs are within.
Right.
It's-
yeah.
Yeah.
It's the stairs that come out.
Well, I don't want to be the one to pick, so what setback would you be looking for there?
If the
Instead
board
of
would be
40
so
Master-
generous to grant a
Oh, I
5-foot
thought you were talking
setback,
about, yeah.
No closer
if
than,
needed,
no
then we
closer
would.
than 35 feet
That goes out.
Right, no closer than 35.
on
Yeah.
the
Yeah.
Sturdy Street
That's
side.
perfect.
Is that agreeable?
Yep.
And we can note,
Yeah.
I gotta remember to put all these things in the decision. No closer than 35, sure. And thanks for pointing that out.
Yeah.
I hadn't seen that. Are there any other questions or issues on this? Applicant? All set? Then is there a motion to close the public hearing?
Do you wanna hear from the public?
Thank you again. I don't know why I'm shutting off the public. Is there anybody in attendance remotely to speak or in person to speak in favor of or in opposition to this application? For the record, I do not see any. Is there a motion to close the public hearing?
I'll make that motion.
Second.
Mr. Tenori?
Yes.
Mr. Spangler?
Yes.
Mr. Noel, yes, the public hearing is closed. Is there a motion for a finding again under 175, 16, forgetting the sub?
C.
C, thank you, that the plan of record as modified by the colloquy here tonight will not make this substantially more detrimental than the existing construction.
I'll make that motion.
Second?
Any further discussion?
No.
Mr. Tenori, how do you vote on that?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes as well. Then we're looking at just one setback, Sturdy Street side, is that right? So applicant has been very upfront with us and has talked through that it looks like the proposed 5x13 deck may encroach somewhat over the 40-foot front yard setback as measured from Sturdy Street on this corner lot, and appreciate the applicant working with us on that. Is there a motion to grant a variance such that the front yard setback measured from Sturdy Street shall be reduced from 40 feet to 35, no more than 35 feet?
I'll make that motion.
No, less than.
Yeah, no
No
less
less,
than, yeah,
thank you.
yeah, I know what you meant, and I was saying in my mind the same thing.
I need an army to correct me.
I'm a yes as well.
Okay. Mr. Tenori, you made that motion?
Yes.
Is there a second, Mr. Spangler?
No.
Second.
Second. And Mr. Tenori, any further discussion? No?
No.
How do you vote?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes as well. Is that all we need on this?
Think
One
so.
variance, I think that is good. Thank you again for the clear explanation and for talking us through that glitch that I hadn't noticed.
Congratulations.
Yeah, congratulations.
Thank you.
Yeah.
Good luck, good luck.
You know, I think
We can make this a half-hour hearing if you'd like. Thanks very much. What?
Build on big.
Oh. Okay. Next is 3 Kingsley Road. Mr. Siganowski is here for that, I believe. Here he is. Oh, we had another one that was going to continue.
That's a.
Yeah.
Oh, there is.
Good evening.
There's a third page to our agenda. Right. Good evening, Mr. Siganowski. Again, to you, I would say thank you as well for your letter of June 28. Pretty nicely setting out what you're looking for and explaining the, why you're here.
No, thank you.
That's, the board appreciates that kind of introduction letter. So it looks to me like this is another finding plus variance to pre-existing non-conforming in the R80 zone, pre-existing non-conforming because of lot size.
Correct, it was a subdivision was created in 1965, the house was built in 68, so we have an 18,000 square foot lot and an 80,000 square foot minimum zone. Frontage on Kingsley, if you include turn is over the 150 that's required, so we do have frontage.
Well, if you include the turn, I get you, because
I'm not really sure how
the turn is
you
the,
interpret that half of the curve.
well, it's the intersection of.
Yeah, so I mean, that curve is required for Kingsley, it's not required for Newland, so I would count that as front, that's why we have the minimum 150 feet of frontage.
On Kingsley?
Right. So we're lacking front lot area. So.
I'm just looking for any dimensions on that. I can see, I can eye it up.
In the chart, I give 152.74 feet.
Oh, you do?
Yeah.
Thank you. And it's also at the top of the property, what direction is that? The northern side is measured at 159.71.
Right.
So it's just less than that. We will go with your, this is engineered and you say 152 frontage. Got it. I see it. Thank you.
Okay. So interestingly, when they built this deck, which my client doesn't know when it went on, because she bought it 5 years ago, the deck is in pretty rough shape, so I'd say at least 20 years. But they actually chamfered the corner so that it is parallel to the property line, and it does meet the 25-foot setback. So whoever did it knew where they were on the lot.
And didn't want to get cited by the building inspector.
Right. So
Interesting.
what my client's looking to do is to convert this from an open deck to basically a breezeway. So it's a raised ranch style house, so the first floor is, 6 feet, 8 feet above the ground, that's where the deck sits. I thought they were doing a full foundation, but they're not, it's just gonna be a breezeway with, a room, walls, they want the privacy, with sitting on posts. So the entire addition is 241 square feet. Going by the town's, on the town information about the square footage, you got 1,034 square feet of the house. This works out to 23.3 square feet addition, so we're under the 25%.
Yeah.
So we're looking to, basically it'd be 18 square feet of area that would be non-conforming, and we'd be at 21.2 if they square up this corner.
They want a square room? That's odd.
Yeah. So we thought about moving the room over, but the sliding glass door is 3 feet from the corner, so then you'd be changing the interior as well as the exterior.
Yep.
That's why we're seeking the variance.
Yep. So the variance relief is on the side yard setback on the north side.
Well, I believe that would qualify as the rear yard.
Yeah.
In this case, it helps us because the side yard in this zone is actually 35, which would be a larger variance.
Right.
This is a rear yard, it's opposite the frontage, so
So this-
25 down to 21.2.
Yep. Rear yard.
Yep.
Okay, and is that the only relief? Yeah.
I believe so.
And it's a finding.
I don't think you need to find it, you're under 25%.
Oh, okay, so it's not here on the finding at all.
23.3 or something was the calculation.
23.
Yeah.
And that is on the plan. here,
Right.
So we're good. All right, so are there questions from the board?
Nope.
I will remember this time. Is there anybody else here in attendance, in the present or by the internet, to speak in favor of or in opposition to this application? For the record, none? Other questions? Nope. From the building commissioner? Nope. Is there a motion to close the public hearing?
I'll make that motion.
Second.
Mr. Denori, how do you vote?
Yes.
Mr. Spangler?
Yes.
Mr. Novak votes to close the public hearing as well. This is in order for variance relief. I think the applicant has shown the hardship, given what's there now. The variance from 25 to 21.2 is minor. I don't have any issue with variance relief for this project. Anything from either of you?
Nope,
No,
I'm
we have
agreeing.
discussion. Is there a motion?
I'll make that motion.
Second.
Okay. Mr. Tenori, how do you vote?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes as well.
Thank you.
Sorry to keep you waiting all that time.
It's always interesting when they have the legal information.
Yeah.
Definitely should have went to court.
How do we decide that? Right? thank you for all the information that you included on the staff
You're welcome.
plan
Thank
as
you,
well.
everybody.
That's what we referenced. Good luck to you.
Take care.
Good
Thank you.
luck to you.
This is like a marathon meeting.
I know, this is why I shouldn't skip meetings.
Yeah.
Now for the main event, Island Brook.
We won't keep them waiting any longer. Good evening, Mr. Itani.
Yes, good evening.
Were you here alone? I thought I saw your sign.
They're on
Frank
Zoom,
Gallagher
too.
and.
Oh, there's Frank. I thought I saw him.
And
I
the
didn't-
Hi,
attorney's
Mr.
also.
Chairman, Christopher Agostino, counsel for Island Brook is here
Thank
as
you.
well.
Thank you. Sorry to keep you waiting. The matter is Island Brook, which has been before us before. Go ahead, Mr. D'Agostino or Mr. Itani. What can you
Sure.
update us on?
Yeah, Mr. Chairman, I'll bring the board back up to speed. If you recall, we were supposed to be before the board on June 20th, but the hearing was continued to this evening because the board was unable to reach quorum. But before that, what we were asking the board to review and accomplish was endorsement of Island Brook's final plan set pursuant to the comprehensive permit. And if you recall, that is a process that involves reviewing compliance with all of the conditions of the comprehensive permit. And in this case, there was also a settlement agreement that had altered certain provisions of the comprehensive permit. So the applicant created a conditions compliance matrix and went line by line through every element of the permit to demonstrate to the board that the final plans that were submitted to the board for endorsement and final approval were in compliance with the comprehensive permit. And during that process, the one element that was raised as something that was still up for consideration under the terms of the comprehensive permit was that the applicant's final plans had proposed phasing of the development into two separate phases that the applicant felt was sort of the logical way to develop the project. And the comprehensive permit and the settlement agreement contemplated that the board would have time to review the issue of phasing, and the applicant would provide the board additional time to determine whether the phasing implicated what is referred to under the regulations as a substantial change to the applicant's proposal. And during the last few hearings, the last one was on May 16th, the board had essentially articulated that if the applicant is going to do phasing, that the first phase would need to essentially stand on its own as a project by itself, if for whatever reason the second phase were not completed. And in going through that analysis, the board identified concerns about whether or not we could loop the water main, whether or not the recreational areas would be placed in phase one, whether or not we'd have adequate traffic access, whether or not some of the other aspects of the development in terms of the ratio of affordable units to market rate units would be maintained. So in reviewing that, the applicant took a hard, in trying to address those issues that the board had raised, the applicant took a hard look at its plans and had discovered that there was sort of an easier way to accomplish the goal. And in doing that, it raised the possibility of redesigning phase two essentially to provide for a single roadway in phase two and then moving the recreational areas to phase one. And we submitted a letter back in June, and we solicited the board's comments to that sort of proposed schematic design that showed that roadway. So that was the letter that was originally drafted dated June 19th. And we were going to discuss that during the June 20th hearing. When we were essentially given the extra month, we had Frank Gallagher, our engineer, go back and continue to refine that revised proposal that's intended to address this phasing question. And so we submitted a little more detail, but still sort of to a schematic design level, with a letter that I just submitted today.
Right.
And, you know, that was submitted just for the board's convenience. And what we're really asking the board to do at this point is to provide some feedback on what we're proposing as a solution to all of those issues that the board had raised with phasing. And then, once we get the board's feedback, we'll decide whether to provide, you know, whether we need to make any additional changes, and then provide a definitive plan set to the board's consulting engineer so that they could do peer review of the plan and report back to the board, since in reviewing this phasing question and whether or not the phase one portion of the site could stand alone, there were several technical issues that the board had raised as far as emergency vehicle access, again, looping of the water main, and functionality of the stormwater management system. So with that, we do anticipate, I think our goal this evening would be to solicit feedback from the board on this design that you have in front of you. Again, it was originally submitted June 19th. The plans today really were just intended to provide a little more detail to the extent, you know, the board wants to discuss any details. But solicit some feedback, and then sort of plan a next steps as far as whether or not we submit this design to peer review by Graves Engineering.
Thank you. I just have a quick question. These plans that Mr. Itani just gave us larger copies of, dated June 18. I just want to make sure we have the right ones.
So actually,
Where's the update? I didn't.
if you're looking at
Thank
the
you.
revision date, the
Nope.
revision date, you got that?
I see the July 18 general revision. Thank you for Mr. Spangler
Correct.
for pointing it out. I always
Yeah,
look
so
at the
it's
bottom.
The latest and greatest is the July 18th, but generally
Sure.
the main, or the revision you'll see is to phase two.
Yeah. This makes a lot of sense. If it's all right.
Please, remind me how the phasing was gonna be split in a different manner before.
Right, so
It was gonna go
what they've
up
done is
the
they've
bottom
moved
bridge.
the dog park and the playground to occupy parcels, as opposed to, they were up here, right?
Which were houses.
Right.
And that
Yeah,
makes a lot of
that
sense.
makes a lot, yeah.
I think, because I looked at these prior, my only, I'm not even sure if I would call it a concern, but we talked about infiltration basin 3 needing to be part of phase 1, and that kind of goes up into kind of a dog leg. And there's a really thin access point there. Does the phasing line also represent the limit of work? And the reason I'm asking is because I think we discussed last time limiting disturbance of phase 2 area. So, you know, how do you construct infiltration basin 3 without, I think it just, the question is, in the further development of this, can you clarify the limit of work if it's different than the phasing line? If that makes sense.
Yeah, no, understood, and I think the phasing line, for purposes of this schematic, is intended to show the units that will be phased, because that was really the critical evaluation from our perspective, but I'm sure that in showing the evolution or more detail of this, we can show a limit of work that would demonstrate how that basin would be constructed, because that was one of the things that Frank had identified when we discussed this before, in that we do need that basin to allow phase 1 to function from a stormwater management perspective. At the same time, the revised design dramatically reduces the overall disturbance, rather than having all that extra impervious area
Much better.
in phase 2 there. So I think that's certainly something we could provide more detail on.
Absolutely.
quick question. The parcels that are now designated for playground and dog park, did those remain, assuming phase two is built, do they remain as dog park and playground?
Yes.
They're not to be moved?
Yeah.
They don't get moved at phase two?
Correct, no, and we actually looked at it, and having those sort of more central to the design provides for sort of open space in the middle, and it's an overall more attractive location for those.
I think so.
Like it.
The board seems to agree,
Yeah.
yeah. That's good creativity. The number of units hasn't changed. Correct?
I don't,
No,
I don't think so.
Still
No.
52.
Yes, yeah,
You just put buildings where there was going to be a dog park and
right.
switched them.
Right,
Got it?
right.
Right.
Plus, both the playground and the dog park are quite a bit larger than what we had in the prior design. The areas for those two amenities have increased, so it'll allow for a little bit more, it'll allow for more
Yep.
as far as those amenities are concerned.
Understood. Questions from the board members? This looks like took a lot of creativity and work, and I like it.
Yeah, me too. I mean,
Does this solve the problems we were bringing up?
I think it does.
The limit of work, so the answer is the red line is not a limit of work line, it's just to separate.
yeah, and I think
Correct.
that's a next level development
Right,
question
right.
probably anyway. Because I'd still want to see the utility plans and some other things here.
This is just to send to peer review to say,
Right,
Yeah.
does this work?
Right.
Are there other questions or issues to?
You did get in a butter letter, I don't know if.
Yeah, thank
You
you.
want to address
Yep.
that at all?
I see the owner's name right here, Jason and Antonella Donovan.
She's on your Zoom call.
Ms. Donovan, you are with us tonight. May I interrupt what we're doing? Ms. Donovan, did you want to say something? I was just going to read your letter into the record.
Oh, I appreciate that. I was just going to say what it was in the letter. If it was possible, if the applicant can do some buffering and keep up some trees for privacy between their properties and mine.
Yep, and the letter dated today, just for the record, not concerned with the project they are building, would like to ask the board to consider keep some of the trees for privacy and buffering between my home, which is 122, and you can see this is their home right here on East Main Street.
There's also, there is a note on the plans that indicates a vegetated buffer to 120 and 122.
They've already indicated on the plans that a vegetated buffer, where did you see that?
Yeah.
What does that entail? Is that like keeping up trees or just putting like bushes around? Just like, how are you gonna separate the two properties? Because I'm not really concerned what they're really building. I'm just more concerned with privacy between my property and the properties they're building.
There is indicated wetland behind you. So
Yes.
So they wouldn't be able to.
They wouldn't be able to touch that area.
Okay, so
That's
does
what-
that
yeah.
mean
Well-
because I'm directly in front of those properties?
Yep.
And there are already trees that are behind me in front, there. And I was wondering how many of those trees would stay up because that is beautiful. It does keep the privacy out. My husband and I did talk about it. If you guys were concerned and you wanted to take down the trees because you're afraid that the trees might fall into my property and damage the property, we've discussed that we wouldn't ask for you guys to fix anything on our property, just to remove the tree. But that would be it. Like, I wouldn't, as long as the trees stay up. I like the privacy. They're beautiful, long, tall trees. It gives a buffering between me and the other 52 properties you're putting up there. Kind of
Understood.
seems like that's gonna be more of a community on their own versus me and the lonely neighbor next to me, you know?
No, I appreciate your comments, the board appreciates your comments. It does show buffers on the plans already, and you can get a copy of these, we can send them to you. the more detailed plans that were submitted today. But it does show buffers. You know, the applicant is here and can, I'm sure, offer some assurance that he'll do what he can in that regard. The goal is not usually to tear down all the trees, you know, next to the site.
Yeah, I think it'd be reasonable in the future.
We can certainly work that
Call
in.
out a zone and say, you know,
We're not at the final approval at this point where we're gonna have exactly what kind of trees and bushes, but Mr. Itani, did you want to address the butter?
I just circled the area for Mr. Atani on that, and gave him the,
Thank you.
plan.
Respected members of the board, my name is Mohammed Aitani, and I'm a managing director of Island Brook LLC. Absolutely, our intent is to keep the buffer. Like what the board mentioned is that there is a wetland area there, so we can't even touch it. Legally, we cannot touch it. Not only that, we have to stay 15 feet away from it based on the approval. So there is gonna be a lot of buffer. And as we're building the houses, we cannot clear anything outside. You can see there's a clearing line. I don't know if you can see it, which shows like hay bales that are running. And and we don't mind adding more evergreens to that line as well. So we will keep what's there, and then we can add few trees where the trees are thin. So we'll be more than happy to do that.
Thank you so much. I really appreciate it.
No, that's fair. That's reasonable.
Thank you.
Thank you for your comments, and we will work in our decision, you know, that buffers shall be maintained where at all possible. So I think you're going to be covered, and I think you will be satisfied. We appreciate your comment, and we will work to try to ensure that.
Thank you so much.
Thank you. Thank you, Mr. Itani.
Yes, sir. Thank you.
I kind of jumped out of order, and there is a letter that will be in the file that was just submitted from Ms. Donovan. You have that, right? You gave it to me, I think, so, okay. What's next? Has this been sent, Mr. Gallagher, has this been sent to peer review today?
So not yet, Mr. Chairman. We were looking to solicit any other refinements or comments that the board might have in kind of looking at this. To, you know, for instance, we just got the feedback about showing the limit of work on the final plan as to constructing that basin. And, you know, we do have the note on the plan, but, you know, maybe we can add some detail about the buffer that was just discussed. But if there are any other sort of, you know, feedback or comments from the board in looking at this layout, then we'd like to kind of collect those, and then we would add some refinements and get this over to Graves so that they could take a look at details like the looping of the water main, location of fire hydrants potentially, and obviously it would be circulated by Brian. You know, the plans set would be circulated for comment, you know, to the fire chief or anybody else that was interested.
So the other plan sheets, we're looking at 3 right now, but the other plan sheets show the underground, the utilities, correct?
Right, so we provided these 3 again, just as sort of the critical ones that show this redesign for schematic and feedback purposes, but we do intend to submit a plan set. You know, the revision date will probably be through August 1st. You know, as soon as Frank, he's got a lot of new grandchildren, so he's been booked this summer playing with the grandkids, but
congratulations.
Once we get him back in front of the computer, he can create a fully developed plan set that includes all of these details, and we'll get it to Graves, and they'll issue a report, and we can move this along.
I think that's a good idea. Members of the board, are you in agreement that this satisfies our concerns, at least what we can see at our level?
Yeah.
So that the rest of the plan sheets can go to Graves. Where are we with Graves? We had made contact with them a month ago or so, but nothing's been sent to them.
Hold on.
If I may.
Yes.
We have contacted Graves. They have made a contract, and I sent it to Frank Gallagher, so the applicant is aware of the contract and how much we still would need to complete the contract.
Yep, understood. Yeah, I think we were just kind of waiting to get our arms around exactly what we were gonna submit. So we'll take a look at that and we'll coordinate to get that, funded and executed and whatever else we have to do.
Because I think that has to be done before we ask Graves to do work.
Oh, certainly, understood, yep.
Okay. So board members were satisfied this is a good revision?
Yeah, I think it addressed everything we wanted to.
And it should be sent.
So maybe that extra month really helped.
Yeah.
Sorry about that, by the way. That was me, I apologize.
Not a problem.
None of us wanted to come that night either, so, but it meant more work for tonight, unfortunately.
I was still working no matter what, so.
So I guess we're suggesting that you finalize with Graves, get the peer review contract and money to the town, or to Graves, I guess, and notify us as to what's being done. Town council is here. Amy, are we on good track with that?
Yes, Your Honor, I have no questions. Oh, Mr. Chairman, I'm sorry. Mr. Chairman, I have no questions.
Wow.
Is that Mr. President?
I don't know.
Are you in court today, Amy?
Yes, I was.
Oh,
Yes.
no.
So, yeah, I have no comments.
Okay. We're satisfied with these plans
Yes.
and thank the applicant, Mr. Itani and Mr. Gallagher and Mr. D'Agostino for presenting to us. So just follow the protocol for getting the contract in place and send the plans on, carbon copying us so that we know where we are. And,
Yeah, so maybe, Mr. Chairman, we could continue this to a date certain and, plan to try to make some progress, maybe in August, and then even if we needed more time, we could continue it. We could notify Brian how things are going. But just to get something on the schedule, and I do think just out of formality, just to confirm, because we had submitted this as a notice of project change back in May, so we'll obviously continue that deadline to after whatever the hearing schedule is, and obviously, as this continues to play out, we'll continue that as needed as we work with Graves. So just, let us know what your hearing schedule looks like. We'll get it on the schedule and then continue.
Yep. Not knowing what Graves' schedule is, of course, but the hearing schedule is, excuse me,
We just have August 21st.
August 21 is the next date for us.
Frank, that's probably tight, no?
Yeah.
Mohammed, what do you think? How's your timeline looking here?
No, September meeting is fine.
Yeah, September meeting's probably fine, and we'll do our best to get something to Graves, early August. I know everybody's slow in August, but we'll try to get them something in August, and then, maybe they can turn it around in advance of your September hearing. I think just to foreshadow a little bit, we had confirmed that the permit is good through January. There's actually some legislation working through the State House to extend all permits as part of the housing production package that's going through the State House right now in light of COVID and, housing costs and everything else. So that may kind of do our job for us, but, as this sort of approaches the end of the year, it's just something to keep in mind. Obviously, we'd like to see this get going. I don't think we need to address it tonight, but if we're into September, and obviously there may be some technical discussion that Graves wants to have, it might take another few weeks.
Yep, we'll come up with our September date in just a minute. If you want to say that, or we can notify you of that. We just haven't, I thought we actually did have a September date.
I just looked and I don't have one.
Okay.
I think first week was August.
Okay. So this sounds like a good plan, and thank you for your assistance. Should we just continue to the August meeting just for a status anyway? We can always just tell the applicant that we'll continue it from there. since we only have the August meeting scheduled, why don't we continue this to August 21 at, say, 7:10? But again, not to box you or Graves or Mr. Gallagher in, just to have it on the schedule so that it doesn't fall off said schedule. And we can, talk informally before then if nothing is to be done that night, and just reschedule it for September from there. All right?
Sounds like a plan.
All right, thank you.
Mr. Chairman,
Yes.
Mr. Chairman, if I may, I'm just, so August 21st is a Wednesday, tonight is a Tuesday. Do you normally meet on Wednesdays or Tuesday?
We normally meet on Wednesdays, however, the
Okay.
past couple of months, we've had,
Okay, just wanted to make sure.
Yeah,
Okay.
this is the unusual night.
Okay, got it.
Thank you. So if that is all for tonight, do we need to vote to continue this? Do we need to vote, Amy, to continue this?
Yes, you have to continue it to a,
Day and time?
to a time and date certain. So most likely your September meeting will be September 18th, the third, that would be the third Wednesday in September.
Is that okay?
Yeah,
That's okay with us, yeah,
Yeah.
we're just setting that
Yeah,
meeting
okay.
right now.
No, I'm just checking. But yes, you would want to continue the hearing to,
Oh.
August 21st, at 7 PM, or 7:10, I think you
Yeah,
said.
yeah. Is there a motion to continue this matter till August 21st, 7:10 PM?
I'll make that motion.
Second.
All right, Mr. Tenore?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes. We're on for August 21, 7:10, however, may or may not have anything to discuss that night, and we will be in touch. Thank you very much.
Thank you, Mr. Chairman. I'll send a letter to confirm continuance of any deadlines, and
Yeah.
I'll confirm verbally as council now that that's extended as well.
Yeah, thank you, and just keep us informed, as I said, your communication with Graves as to timing, so appreciate that.
Great.
Thank
All
you.
right, thank you very much.
Thank you. Thanks, everybody.
Thank you.
Thank you.
Appreciate it.
Yeah, have a good
Good
summer.
night.
Yep. Okay,
Mr. Chairman, do you need me to stay on, or?
Can she stay for a minute? I have a question after.
actually, yes.
I'm glad I checked.
Is it on the next application?
No, it's after that. I just have a question on something else.
Quick question, but the next application is to be continued, is that correct, Brian, Mr. Carmichael?
yes, so
Yeah.
we just started having applicants mail out their own letters. And so they sent out their letters, however, they didn't pay with the Sun Chronicle. So they did advertise halfway, so we have it on the agenda, but we have to continue it because they didn't do it fully.
What does that mean, halfway?
They sent it out to the abutters, but they didn't do the legal ad.
I see. So this is on our agenda.
But we have to continue.
Okay.
So, Mr. Carmichael, if I may,
Sure.
the statute requires that the town do the notice,
Okay. I was not aware.
unfortunately.
Okay.
Thank you.
People do their own.
Yeah, that would.
So does
So
that,
you are responsible to send out the hearing notices and send it to the newspaper. Obviously, they are required to pay for everything, but it's on the board to send it out under the statute, under section 11, 48, section 11.
Thank you, Amy. I didn't know that.
Okay.
Paul thought otherwise, but okay.
we're blaming Paul.
Yeah, let's do that.
That was quick. That
Yeah.
was easy.
We like blaming Paul. Does that reverse anything that's been done then, or do we,
No.
can we jump in here?
Yeah,
and
It would only be significant if somebody challenged it, but no, right now, no. So just from now on, do it.
So for this
Okay.
matter, you can pick up what Amy is saying, send the notice or create a notice or something?
Yeah, I'll get the legal ad for
Okay.
August.
Talk to Paul and.
Yeah.
Okay, thank you. Then, is there a motion to continue the application of Robert Amaral? The applicant is actually Timothy Filrillo for 78 Barrow Street, to the August 21st meeting date at, say, 7:05. Is there a motion?
I'll make that motion.
Second.
Mr. Tenori, how do you vote?
Yes.
Mr. Spangler?
Yes.
Mr. Noel votes yes as well, so 7:05 on August 21. We'll see if we can get it done for then. That is the end of our agenda, except for general business. Mr. Iafrede, did you have a question for council?
Yeah, Amy, can we discuss something from the first item on the agenda real quick, just so I have clarification?
Samoset?
Yeah. Can we do that, or, but, well, I'll ask the question, you tell me to quiet or not if you have to.
Okay.
So, based off of everything we've talked about, Big Now is a right-of-way, not a street, right?
Yeah, right.
So, with it being a right-of-way, not a street, the applicant and the neighbor across on the other side of the right-of-way both own 10 feet of that right-of-way. It's a 20-foot wide right-of-way, correct?
Correct.
What type of issues do we now have that he paved 14 feet of that right-of-way with no permits? And then on top of that, what type of issues do we have that he paved that right-of-way in general at all with no permits? If he can't pave that right-of-way, now what's the next step from the town standpoint?
So there's really no next step from the town standpoint. He can, so with the derelict fee statute, meaning that he owns to the center line, he also owns the ability to pass and repass over that.
Yeah.
Over whatever his frontage is on Bignell Street, he has the right to pass and repass. And with the right to pass and repass comes the right to improve. So he technically does have the right to improve that. My only concern would be, which is a private matter, would be between him and New England Telephone, which is now Verizon, because if he paved any of they have a superior right of easement to put poles in. And so if his paving or anything affected their right to put in poles, they would have the right to make him take it out. But that's not up to us. That's a private matter between the two of them. His attorney has said that, Verizon responded to him that they don't know of any rights that they have to that, but that's not the same as having a full title search saying they have no rights. They might have rights, we don't know, but,
Right.
But what he did, I think he could claim he did under the pretext of the fact that he has the right to pass and repass over Bignell Street.
Okay, so no.
Or right away.
No pole line.
Yeah, no violation, no next steps from my side. Let's say theoretically or hypothetically, if the other abutter that owns 4 feet of pavement that he created has a complaint, that becomes a civil dispute between them?
It does, but I don't think they have much of an argument because, again, he does have the right to pass and repass, which means he has the right to improve the entire right-of-way.
Yeah, and there's no correspondence or grounds for me expecting that to happen. I'm just asking for my own knowledge, in this situation, so. But thank you. That's all, that was my only question. And thank you for staying for that.
Thanks very much,
It wasn't a
Amy.
long wait.
Appreciate the help tonight and always.
Okay.
Thank you.
So
Good night.
I will be here on August 21st unless I hear that it's continued.
Yeah, great.
Okay.
Thank
All
you.
right, perfect. All right, have a good night, guys.
Good night, Amy.
Bye.
Are there any bills or warrants? Okay. Just one thing, I did get sworn in a couple weeks ago when you asked that.
Oh, yay, thank God. Thank God.
But,
Your
no,
hair's starting to look like
two,
his.
isn't it two?
What's that?
Your hair's starting to look like his.
Tell me about it. It's
I
my
don't
job.
remember.
I think it's 3, isn't it?
I got the letter from the selectmen, and I just put it away, I didn't answer it. But they brought it up at the meeting anyway, so. But we're supposed to vote for a chair every year. We've done it in the summer, at the end of the summer. So how about if we do that in August? I'd encourage anybody who wants to be chair to step forward.
I can't be chair.
You have to be a member to be chair? It's like in
Yeah.
Congress. You could be Speaker of the
Hey,
House.
can we vote,
You could be Speaker of the House without being a
Lucas.
congressman. Yeah.
We're voting Lucas. Yeah.
Right.
If he doesn't come, that's his fault.
Well, that's a good point.
Right?
And then, chair and vice chair, right?
Yeah.
Lucas takes top notch.
Yeah, that's it.
All right, well, let's put that on the agenda for the next meeting. But if anybody would like to, you can step forward at that time, but let's put it on the agenda. anyway.
But his name is Tom, right?
The-
Yeah.
For next
At this
meeting for
point,
August
this is
21st.
just getting hard for me to get
I know.
It's getting hard. With kids' sports and work and
I
this
know.
is tough.
I hear.
So, I do apologize on any late
Yeah.
cancellations. I try and give you guys as much notice as possible.
Things come up for everybody. We handle it as best we can. Okay?
We have the minutes. I gotta be honest with you, I have not looked at them,
I haven't either.
so
Let's try to look at them for August 21.
Yep.
All right?
I'll
Thank
make it
you.
a priority.
And hopefully there will be more. There
Okay.
should be
Okay.
more.
Yeah, I'll try. If you email them, I will make a note to read them before my hour bedtime.
Don't make them,
That I
don't fall
have.
asleep in the first line, Jim, don't worry.
All right, fantastic.
Nick, thank you very much for
Absolutely.
coming in and explaining.
Yeah.
As that was a big uncertainty for all of us, Samoset, with the history.
Yeah.
So I thought this might have looked familiar. I might have seen this in '06.
It's been
Yes.
a while.
Was there
So
a
I did
decision
check.
or something?
There was a decision, basically, it looked like the same thing, except it was conservation instead of planning board.
So conservation issued an order of conditions for this project in March of 2022.
March of '22, okay.
But they issued an order in 2022. But it's not conservation's purview to determine whether or
Right.
not
Mhm.
it's applicable to zoning or anything else. So they
Right.
didn't, to the best of my knowledge, they didn't cross any lines or do anything they shouldn't have done. They had an application in front of them based off of environmental concerns, and they made a judgment or a ruling. From the sounds of it, the applicant took that as
I can do it.
to do what he did.
Yep.
But it was confusing, because there's also a bunch of legal
Yeah.
mumbo jumbo behind it that says if he went in, created a subdivision plan, he's now losing his pre-existing non-conforming protection
Oh.
because it doesn't meet the current requirement of zoning. There's a bunch of legal stuff, background to it. So that's why he was kind of hesitant to go and do that.
That's what I was trying to get at, that there might be other options.
Like a
and-
Form C or something like that for the planning board that he didn't want to file because he was afraid he would lose his protection.
I just didn't understand why the planning board took a vote, but there's no decision. But
Yeah,
we-
it makes sense.
Because, as I had said in the email, I don't know what exactly the decision would be written, so.
But
the
then,
chair
why did they
didn't-
take a vote? Why take a vote if you don't know what you're voting on?
I mean, we can look back, I'm gonna look back at the meeting. I didn't know about the meeting, recording and all until today, I think, maybe yesterday, but I'll look back at it. I'm just curious,
Yeah.
because that was my point, if they didn't.
I'll talk to Alan. I'll call Alan.
Alan, I mean, you're still recording.
Yeah, we're
Yeah,
still
we're
recording.
still on.
Alan expressed his concerns at that meeting. A lot of the board members had questions, concerns,
Yeah.
but I think watching the video, town council wasn't there.
Yeah.
The applicant gave his opinion, which is nothing wrong with that, but he gave his opinion of whether or not it was, he kept calling it a street. So I think after speaking tonight, there was a little bit of, there's a difference in opinion which one way or the other could sway an opinion of the project, right?
Yep.
Depending on the situation. Without knowing the legal background, I can understand both sides of it, but
I was just looking, I had asked, so is there a decision we should be looking at? But there
Nothing.
isn't one, so. Okay, so nothing else to come before us tonight?
Nope.
Motion to adjourn at 8:59.
So moved.
Second.
All those in favor?
Yes. Aye.
Thanks, everybody.
okay.
Meeting is adjourned.